Hey everyone, this is our second presentation. It's the case brief. This is Kelly.
And this is Jennifer. And we're going to talk about a case that's got animals in it, or an animal in it. So the caption of our case is W.E. Overby, who is the petitioner plaintiff, versus G.E. Poteet, who's the respondent defendant. This case was, this opinion is resulting from the opinion of the Supreme Court of Tennessee, and it was written on February the 5th, 1960. The Westlaw citation is Overby versus Poteet, 332 Southwest 2nd, 197, Tennessee, 1960, showing that it is a Tennessee Supreme Court case. We put a hyperlink in, but it made it look like the whole thing was underlined, so that's why we did that separately. The facts of this case are that the defendant, Mr. Poteet, owns a farm up in Williamson County on a blacktop road leading into Nashville. The farm's pasture is enclosed, and according to the facts, it's enclosed by a well-maintained fence, which is standard for restraining cattle. The fence is 46 inches high. It's made up of woven wire with a strand of barbed wire across the top. The fence is standard cattle fencing, and the defendant has used this type for 14 years to enclose his pasture. And in that 14 years, he said he's only ever experienced 3 to 4 times that his cattle were able to break through the fencing, and the fence posts are in good shape. The defendant, Mr. Poteet's steer, broke through the pasture fencing and got into the highway. The steer weighed about 1,200 pounds. The plaintiff in this case, Mr. Overby, was driving along Hillsborough Road at night on December the 15th in 1957 when he ran into Mr. Poteet's wayward steer. Now, we need to note that the steer was neither vicious nor did it exhibit that it required any special attention. The defendant did not know that the steer had broken through the fencing until he heard about the wreck. The defendant acknowledged that the steer did break through the fencing, apparently getting through the top of the fence, but he went on to say that no fence can hold a large steer if it decides it wants to go through it. So the continuation of the facts is that Mr. Poteet, the defendant, prevailed in cases that were filed against him. Mr. Overby filed cases in the Sessions Court in Williamson County, that would be county if you put a T on there, and the Circuit Court of Williamson County, and in the Court of Appeals. And here I think we should, since we talked about the synopsis is not written by the court but is written by the editors of the opinions, is to note that in the synopsis of this case, it's the Westlaw synopsis says that the plaintiff brought suit in the Chancery Court for Williamson County, but the opinion itself states that it was in the Circuit Court of Williamson County. We went ahead and looked at Justia and Legal and found out that they both say the Circuit Court too, so it appears that was likely an error in the synopsis. So after all of that, the plaintiff brought certiorari or a request to the Supreme Court and asked them to look at his case. So the procedural history in this case is that the Sessions Court of Williamson County entered judgment in favor of the defendant, that the circuit judge, there was not a jury, and I don't think our video is going to play because we're having to sit out in the parking lot of Panera Bread. The circuit judge there filed a memorandum and just said that the defendant was not guilty of actionable negligence and that the plaintiff was guilty of contributory negligence, which would keep him from getting any recovery. The Court of Appeals affirmed the judgment of the Circuit Court, and then the Supreme Court granted certiorari and agreed to take a look at the case. There is no subsequent history after the Supreme Court ruling. The first issue in this case is, did the defendant have fences encompassing his pastures that were sufficient restrain the livestock they held. So that's the first thing that the court had to address. They held that the lower court's ruling that the defendant did have a lawful fence, that he did have a lawful fence, and that the fence he used was ordinary fencing used to restrain cattle. The rule of law in this case was first the statute, which is TCA 44-1702 was what it was in 1960, where the court looked at the definition of what it's called now as materials or sufficient fencing. But they also used the case law set out in the Wilson versus White case, which is the Southwest second case, and that too should be over closer to that period right there. I can't tell if it is or that's just the way it printed, but well, that's really bad. I didn't even put, is that right? No, it's supposed to have the year. Mm-hmm. Okay, that whole site is wrong right there. But at any rate, Wilson v. White talks. They used that case as well as the rule of law. The court, in its application of the rule, first started out by saying that the facts were undisputed, and all they were doing is look at whether the lower courts, that they were right on the law. They applied the fact that there was no dispute that the defendant's pasture was fenced, and the question was whether it was sufficient. And according to what the law said was sufficient fencing, they found that it was sufficient. And they also found that it was it was ordinary fencing based on the Wilson case law for what fencing is used to restrain cattle.
Issue number 2 is, did the defendant exercise ordinary care in maintaining his fences and in his own effort to keep the livestock in the fences? The holding is the court affirmed the judgment of the Court of Appeals and hold that TCA 44-1401 makes the owner of escaping animals liable only where he knowingly or negligently permits their escape. Hence, the first 2 assignments are overruled. The rule of law was the statute of 44-1401, rights and duties of owners. The statute making it unlawful for the owner to willfully allow his livestock to run at large was designed to cover both the private property of others as well as highways, and the purpose was to prevent domestic animals from straying anywhere on account of the negligence or willful conduct of the owner. And under the statute, the owner of escaping animals is liable only where knowingly or negligently permits their escape. And then further on is injuries by animals at large. The owner of escaping animals is not liable if, without his fault, the animals have escaped from a pasture enclosed by lawful fence or by ordinary fence, such as generally required to restrain that kind of livestock. The application is the rule is not one of absolute liability, but depends upon failure to exercise reasonable care to confine or otherwise control the animal. And secondly, that the harm is of a sort which it is normal for animals of its class to do. Mr. Petit did exercise ordinary care in making sure his fencing was in proper place, height, and that maintenance of the fence was maintained. Issue number 3 was the plaintiff guilty of contributory negligence. The holding is the court held in this case that it was determined the defendant was not guilty of any negligence. There was no necessity in discussing contributory negligence on the part of the plaintiff. Therefore, there is no rule of law of application to discuss. The judgment was the Tennessee Supreme Court affirmed the ruling of the Court of Appeals. This opinion was written by Justice Swepston, and there is no record of concurrences or dissents for this opinion. And that is all for our presentation. Thank you so much for listening.
Hope y'all have a great week.